So welcome everyone to the panel, the role of OECD in Latin America, the dynamics of the regulatory convergence in personal data protection, which is organized by Data Privacy Brazil Research Association, which is an NGO based in São Paulo, and which I'm a founder director. So just to explain the role of the panel and the NGO itself, Data Privacy Brazil is an NGO that conducts research and does advocacy on the intersection of technologies, privacy, and fundamental rights. And to anyone who is interested to learn more about the Brazilian data protection law, I invite you to access our website, and specifically a project called Memory of OLGPD, which is a doc series with more than 3 hours of interviews translated to English. And one of our ends at the NGO is also to frame the discussion regionally in South America, and that is the purpose of this panel, which gathered a stellar team of speakers to reflect about what are the strengths and the perils of the so-called regulatory convergence and how OECD fits on it. So as you may know, along with Convention 108, the OECD's guideline is one of the most influential normative documents in the field of data protection. And despite the existence of several generations of data protection laws worldwide, the core normative principles are more or less the same that were prescribed back in the 80s when the OECD's guidelines were enacted. Even the accountability principle, which is nowadays seen as a normative pillar of the latest generations of data protection laws, was already provided by the guidelines. Nevertheless, the context that we have now is completely different in comparison to the 80s. In this sense, after 33 years, in 2013, OECD has revised and renewed the guidelines by publishing the privacy framework. And there are several new countries that joined OECD's since 80s. Mexico, Chile, and Colombia, just to name a few of countries based on Latin America. And more are coming, especially from South America. And of course, the business model, public policies are much more data-driven than we have ever seen in our history. So considering that, I'd like to ask Christos, the representative from OECD, what are some of the last developments of the renewed agenda of the OECD in terms of personal data protection? And please give some examples of OECD's work on the subject, especially in Latin America.
Yes, well, good morning, everyone. First of all, I would like to thank everyone for the organization of this panel and invitation to share some views. Just a little bit of a disclaimer. Actually, the representative of the OECD, Elettra Ronchi, she was not able to join in. She was actually kindly asked me to cover some of the work of the OECD in particular, the revision of the OECD privacy guidelines. So the intention of my participation, which is very, very limited, I mean, because of the time constraints, will be very much focused on like giving you some perspectives and outsides on what the OECD privacy development process consists on. And also I will touch about like some of the aspects that the OECD is currently involved in. Perhaps you might heard about the OECD digital Going Digital project. Well, the OECD has actually came up with a few reports and it covered Brazil. And I had the pleasure and the great opportunity to be involved in the process and collaborate in the drafting of this report. So I will touch my discussion, well, my intervention also will touch about some relevant aspects of the report. I mean, the report is quite comprehensive because it covers like not only policies concerning digital security, consumer protection, and privacy, but also other issues concerning also telecommunications. So mine, it will be specifically covering, the things concerning privacy included in the report. Well, as I mentioned before, you might be aware that the OECD started this OECD privacy guidelines review process 5 years, like in 2013. So, and then like the OECD guidelines were started to be reviewed in 2018, and as it was mandated by the OECD Council. Well, the scope of the review essentially was to evaluate the implementation, dissemination, and the continued relevance of the recommendation, and whether the instrument required version or further actions to support the dissemination or further implementation. The review process was actually approved in 2018 by all the different member countries of the OECD. Also, to inform the review, the OECD established in January 2019 a working group of experts on the privacy guidelines, which was actually co-chaired by the former Privacy Commissioner of Canada and also the Deputy Secretary General of the CNLI in France, and also included the participation of more than 60 different international experts very active in the field. Also, the OECD also based the review on evidence collected through an online questionnaire, roundtables, workshops that were jointly organized with a number of other governmental actors as well as non-governmental partners, including the recent Global Privacy Assembly and Japan's Personal Information Protection Commission, just to name a few. Also, the OECD also undertook an analytical work to examine in depth a number of complex areas, such as national privacy strategies, data localization, and transparency reporting. I mean, those are 3 areas that also the OECD has also been focused in the last year, and it is expected to focus also in the coming years in other countries. Well, now I will sort of like give you some main takeaways from the 2018 review of the privacy guidelines. Well, the overall results indicate that the privacy guidelines still remain an essential reference for countries on minimum standards for privacy and personal data protection. Also, the principle-based technology, neutral, and risk-based approach of the privacy guidelines is also widely recognized, not only as a solid foundation for building effective protection and trust for individuals, but also for developing common international approaches, particularly with transborder data flows. Also, the OECD workshops organized jointly with the Global Privacy Assembly on the COVID-19 crisis, having particularly highlighted the continued relevance of the privacy guidelines and the different 8 principles that are contained therein. As you might know, these principles also continue to give countries a clear indication of the standard level of protection expected by the global community on data protection. Also, the review also indicates a strong positive trends in member countries that are updating the privacy legislation. And the OECD is of the opinion that most of those privacy revisions are also very much consistent with the 2013 revision of the OECD privacy guidance. It's also important to mention that despite the progress that has been achieved so far through the OECD, the analysis of the guidelines also identified a number of significant challenges in implementing the guidelines in different countries, especially against the backdrop of technology developments, which continue to evolve and to create tensions with established legal norms, and which will require the development of additional guidance. So in essence, that's the work of the OECD concerning the revision of the privacy guidelines, which, as I mentioned before, is still an ongoing work. Now I'm just gonna very briefly focus on the the report of the Going Digital in Brazil. Well, first of all, you might be aware that the OECD has a project which is called the OECD Going Digital Project and Toolkit. Well, this project aims generally to help countries assess the state of digital development and to formulate policy strategies and approaches in response to including digital security and data privacy policies. As part of the implementation of this project, the OECD elaborated the Going Digital in Brazil, which was originally published in October 26 last year. Well, the report, the OECD Going Digital in Brazil, reviews trends in digital technology usage among individuals, businesses, and governments, and also examines policies to foster diffusion. The report discusses efforts to enhance trust in the digital economy and focus inter alia on digital security, privacy, and consumer protection. This report also provides recommendations to foster synergies across government ministries and institutions and to increase the policy coherence based on the OECD Going Digital Integrated Policy Framework. Now I will briefly touch on some of the most relevant aspects of the Going Digital in Brazil report. Well, the report underlines or highlights different aspects concerning policy developments in Brazil. One of the most important, and I would say, it's the criteria of an independent data protection authority. So the report highlights, for instance, that administrative and legal frameworks that leave open a small possibility of a privacy enforcement authority being instructed by another administrative body on how to exercise functions do not fully satisfy the independence criterion. And pursuant to the 2003 privacy guidelines, and particularly Part 5 concerning national implementation, the OECD calls on member countries to establish and maintain privacy enforcement authorities with the governance, resources, and technical expertise necessary to exercise their powers effectively and to take decisions in an objective, impartial, and consistent basis. Also, the OECD underlines the importance of the need for a privacy enforcement authority that is essentially free from instructions, bias, or conflicts of interest when enforcing the national legal framework. Well, in general, the national DPA must remain free from any internal and external influences. Also, another relevant aspect of the Going Digital report in Brazil concerns data breach notifications. The LGPD, the Brazilian Data Protection Law, establishes that the communications of the controller to the national DPA and the data subject must take within a reasonable time period. However, this situation still merits further clarification in the future regulation of the LGPD. Another important aspect of the report also concerns implementation of a governance program on privacy. And this is important because this is not only an issue that is particularly related to Brazil, but also to other countries of Latin America. I mean, according to the OECD, there's a pending task that needs to be addressed by the national DPA, particularly for institutions of the public sector that collect and process personal information on data subjects. Also, another important finding of the report deals with the issue of cross-border enforcement cooperation. Pursuant to Section 4 of the 2000 of the OECD revised privacy guidelines, it highlights the importance of cross-border cooperations in the enforcement of privacy laws and the facilitation of mutual assistance among privacy enforcement authorities. So the OECD reports that Brazil should explore joining, for instance, the Global Privacy Enforcement Network and similar international networks to strengthen cooperation in the area with other countries. Another relevant aspect, and perhaps I will also leave it there, concerns with the development of data governance frameworks. The legal frameworks and norms governing, for instance, access to and sharing of personal data consist of a global regime of sector-specific laws and a patchwork of laws and regulations that include sort of like state and municipal laws that govern access to information and data protection in different sectors of the Brazilian economy. The OECD recommends in this regard that there should be a future clarification on whether the aforementioned laws should consist for some time or how they might be superseded by the LGPD. This is an issue that in the eyes of the OECD is still pending to be done. And there are some other findings that the report contains that I would very much encourage, I mean, not only the participants of this panel, but also the audience to check and revise this report, which is available on the OECD website. And I would be very happy to post the hyperlink so that Bruno might make it available to our audience. So with that in mind, I will conclude my participation, and I would very much look forward to the future interaction and questions on this panel. Thanks.
Thank you so much, Criso, for this really comprehensive overview of the OECD's scenario and focus particularly on the latest report called Going Digital in Brazil report. So bearing this in mind, I'd like to move to Miriam and ask her about the intention of the Brazilian government of entering the OECD is widely known. And however, the organization has made clear over the years and recently in that report that was already mentioned, Going Digital in Brazil report, that one of many aspects or more relevant aspects Brazil would have to address the establishment of an independent DPA. What is your assessment of the current situation in that regard? And also another relevant feature of the report is the recognition that Brazil was able to create a very influential multi-stakeholder government and strategy, such as the Brazilian Internet Steering Committee. And LGPD also created a multi-stakeholder national council alongside of the DPA. So could you elaborate about this institutional arrangement provided by LGPD?
Of course. Thank you very much, Bruno. It's a great pleasure to participate in this important debate along with the other distinguished speakers. And I'm very happy to answer your question because, in fact, before working at the Brazilian DPA, which is my current position, I used to head the department at the Ministry of Science and Technology that was responsible for the OECD peer review on Going Digital on the Brazilian side. So between 2018 and 2020, the team at the OECD responsible for the peer review came to Brazil on 3 different missions. We had a very high level of interaction. They interviewed a large group of stakeholders in order to reach their final conclusions. So I'd like to provide some context on the peer review, which originated this report, and also to speak a bit about the motivations of a country when it decides to commission a peer review of this sort. When the peer review was actually commissioned at the end of 2018, the Brazilian government had just recently approved a Brazilian strategy for digital transformation, which is a framework which is very closely aligned to the OECD Going Digital framework. And it was very clear to us at that point that a key aspect of digital policies involves creating trust in the digital environment. And this includes different aspects involving cybersecurity, consumer protection, but of course also data protection. And as you may be aware, in August 2018, our general data protection law had already been approved, but it was not yet in force, and the National Data Protection Authority had not yet been created. So it was a very interesting period where our policies in the field of privacy and personal data protection were in fact coming into force, were beginning to be implemented. And I think it's important to note that when a country voluntarily decides to submit its policies to an external review, as is the case with this peer review, which originated the Going Digital report. In many cases, we already have a clear idea of what the problems are and what the possible recommendations may be. So a report of this nature is important not only to bring us new insights, and this is a very comprehensive report, as Christos was mentioning, but also to highlight issues that maybe need to receive a higher priority in the domestic agenda. And it was very interesting because the launch event of the report on October 26th, that Christos also mentioned, was only a couple of days before the directors of the ANPD were formally appointed and our National Data Protection Authority was formally established. I think it's important to note also that when Brazil announced its intention to join the OECD in 2017, this represented a clear commitment from government to adopt best practices in several different fields, ranging from science, technology, governance, security, all the issues that the OECD deals with. And the idea, of course, is to help us improve our legal and our institutional framework and to increase legal certainty, which is important for citizens, but also for our economic growth and development. So in the field of personal data protection, we were in fact very happy with the OECD recommendations because they in fact stated issues that had already been clearly identified during the legislative debates that led up to the approval of the LGPD. I'd highlight some of the key recommendations. Of course, Christos has already mentioned them, but especially important are the recommendations that we should reevaluate and amend the conditions establishing our National Data Protection Authority to ensure that it operates with full independence, which is the point that Christos also made, to ensure that the rules for appointing the Board of Directors and the National Council for Protection of Personal Data, which is our consultative board, are transparent, fair, and based on technical expertise, and to guarantee an adequate and predictable budget to our National Data Protection Authority through a transparent process. And here I think it's important to clarify, because maybe not everyone is familiar with the Brazilian scenario, that our National Data Protection Authority was in fact created as part of the Presidency of the Republic, which is of course not ideal, but this is a provisional format, and our law states that within a 2-year time frame, we have to reevaluate the legal nature of ANPD in order to provide it with a legal status that grants greater independence. So we have at this point in time some mechanisms that guarantee independence. For instance, the directors have a fixed term. They cannot be dismissed without a formal procedure involving proving that there was some serious irregularity. We also have freedom to create our own staff, to hire people. But since we are connected to the presidency, this framework is, of course, not ideal. And the proposal that we are currently discussing is that ANPD, which is our National Data Protection Authority, should become a special autarky, which is a legal institute in Brazil. That means that we would be part of the indirect administration and thus not be submitted hierarchically to the presidency of the Republic. And this is something that the current board of directors is certainly committed to working on. And in the meantime, I think it's also relevant to note that this is all very recent. The DPA was created on November 6th last year, so it's only 3 months old. And we're working very hard at this point in time to create our basic structure for functioning. So, for instance, drawing up our internal rules of procedure, hiring staff, and establishing our priorities in terms of decision-making and issuance of regulations. The structure of ANPD was conceived taking into account that we are in a very complex framework in terms of enforcement, and also having in view that we need to have an intense dialogue with civil society, with other bodies with responsibilities that are similar to ours. And thus, Bruno, I'd like to highlight the point you made of the importance of our consultative committee, which is a multi-stakeholder body, and will certainly have a very relevant role in terms of providing advice and establishing priorities for our work. I'd like to pause at this moment so that we have time to listen to the other speakers, and I'd be happy to further elaborate when we get to the questions. Thank you.
Thank you so much, Miriam. It was very, very, very clear, and I think provides some food for thoughts in terms of what is the tendencies for this year in Brazil in terms of enforcement, and also highlighting the importance of the National Multi-Stakeholder Council. Christos mentioned in his talk how the revision of guidelines was led and inspired by risk-based approach in the field of data protection and regulatory rationality in general terms. And I'd like to move to Giovanna. CIPO was very, very active during the OECD's journey to review its privacy guidelines. CIPO was not only part of the working group on information security and privacy, but also the rapporteur of some important discussion documents at that time. For instance, data protection accountability, the essential elements. Could you please describe the importance of the accountability principle and what is the role of OECD and its privacy framework to make this principle tangible across different countries, especially in South America?
Yeah, of course. Thank you, Bruno, so much for inviting me for this panel. I'll try to be brief because I know we don't have a lot of time. Just really quickly, CIPO, I just wanted to explain, CIPO, Center for Information Policy Leadership, is a global privacy and security policy think tank. And we work with regulators and organizations such as the OECD and GPA. We work with member companies. We have more than 90 member companies who are market leaders in privacy and security. And we, our goal is to put all these people together and facilitate information and build bridges between the areas. And one of our biggest areas of work is on accountability. And indeed, Bruno, we worked with OECD in the revision of the guidelines in 2013. Chris has mentioned the working groups and the civil society organizations and think tanks working with OECD after 2013, and CIPO was one of them. We held a workshop and a consultation on the topic of accountability and published the paper. We have been publishing many papers on this topic since then. Our latest report as well, following the discussions that we had during the OECD privacy review guidelines on accountability mapping, trying to fill a gap, which is organizations and DPAs asking, so how does this principle work in practice? So in this report, we actually show examples, real case studies of how organizations implement this principle. So maybe one of the things to take away as well. And our president, Boyana Bellamy, as well, sits in the expert group reviewing the privacy guidelines. So we think that OECD has a major role in here because they are one of the only international organizations and fora that facilitate discussions with in an international global scale, and also involving multiple stakeholders like CIPO and other think tanks, industry, governments, regulators. So indeed, OECD and other fora as well, like the GPA that Chris has mentioned, they're really unique, and they have this global importance. And also OECD has regional activities and initiatives like in Latin America and other regions as well. So it has that channel to bring the discussions also to a regional level and encourage best practices, encourage the adoption of principles such as accountability. So let me explain a little bit what CIPO understands as accountability. Initially, accountability was a co-regulatory mechanism. It was sitting on top of laws. It was an addition to laws, an extra layer of corporate responsibility, and of course applying to public and private organizations. But we're seeing this principle incorporated more and more in data protection laws around the globe. But also, it's not a principle that's specific to data protection. This principle, for many years and decades, has been applied in many other areas of corporate compliance and responsibility, like anti-money laundering and corporate investigations and other areas of compliance. So it is a principle that is familiar to organizations, public and private. It is a principle that's familiar to senior leadership. And therefore, it is a principle that works as a bridge to bring data protection discussions to corporate leadership and help embed those discussions in the corporate culture and DNA, because it gets the attention through common frameworks that apply to these many laws, it gets the attention to senior leadership. Accountability can be summarized in the way that organizations apply mechanisms, policies, procedures, tools to comply with the law in practice in an effective manner. And there are many mechanisms for this. And the most common mechanism that is mentioned in many data protection laws, including the Brazilian law, Colombia, and Mexican as well, is implementation of a data protection compliance framework, and also being able to demonstrate such compliance. And there are many different ways that organizations do this, and there are many different frameworks for organizations to do this. For example, the OECD Guidelines provides a framework when it has many principles to data protection, but also we see frameworks in binding corporate rules. Certifications are also a way that organizations use to effectivate this principle. And also frameworks like the Simple Accountability Framework and many other similar frameworks created by consultancies and law firms. But normally we see some elements that are common to all of these frameworks that translate the accountability principles to real life for organizations, which are leadership and oversight. So organizations' leaders have to be involved. There needs to be tone from the top. There needs to be oversight in the mechanisms used for compliance with data protection laws, as well as policies and procedures to implement the laws, as well as transparency, training and awareness. Risk assessment, you mentioned, Bruno, risk as being one of the elements, and indeed it's recognized in the beginning of the OECD guidelines as one of the overarching goals, which is a risk-based assessment. So being able to prioritize, being able to focus on the main areas of risk, as well as response and enforcement, actually enforcing the program, enforcing the policies and procedures, and ultimately enforcing the laws. We see all of these elements being demanded in various different ways, and in all of these frameworks. Accountability then actually helps embed data protection in the corporate DNA of the organizations. And again, just to finalize my talk, we've been working with OECD and seeing OECD as this really important for discussion, to bring in and join different stakeholders to discuss these elements. And what we want is OECD to encourage the use of accountability in organizations in different countries, and accountability frameworks being used to facilitate cross-border data flows, to facilitate interoperability between different laws, and to work as a mechanism to respond to trends that are a bit worrisome, like data localization and government access to data that we saw an increase during COVID times. Accountability frameworks actually bring a common framework that enables a response to all of these worrisome trends, and also enables interoperability between data protection laws around the globe, and therefore data flows. Thank you very much, Bruno, and looking forward to the questions at the end.
Thank you so much, Giovanna, for providing details and what is the importance of the CIPL in terms of framing this debate about accountability, and not only at OECD, but also I can say during the discussions of LGPD in Brazil as well. So I'd like to move to Maria. Maria, there is a widespread discussion about the influence of GDPR over the new generation of comprehensive data protection laws in the global South, and especially Latin America. Another debate is, however, the scope of the power of organizations such as OECD in shaping public policy related to data protection, which includes regulation, but goes beyond, encompassing aspects such as enforcement network, for instance, Japan as well. What do you believe are the positive and the negative implications of that sort of influence for data protection in the region?
Thank you very much, Bruno. Thank you for the invitation to be part of this panel today. So only as a way of context for the ones that doesn't know me and my organization, I am the Executive Director of Derechos Digitales, a non-profit organization that works in regulatory and policy issues in Latin America from the perspective of the human rights. So how technology, and in this case, the use of data, personal data, that is utilized by these technologies can have impact in the exercise of human rights. So from that perspective, the first thing that I have to say regarding the question that you present to me is that the influence of GDPR in the recent wave of legislation around data protection in Latin America is something that it happened in a very organic and natural way, and it's precisely linked with the fact that the same that in the case of Europe, in Latin America, the idea of regulation and protection for data, personal data, is anchored in a perception of human rights. So the same that in the European Union, these have the link with the fundamental chart of rights, of human rights of Europe. In Chile, and it's my country, but in other Latin American countries, this is anchored in the recognition in the majority of the constitutions of the right to privacy, or directly the data protection rights in some of them, and also in the American Convention of the Human Rights. So in that sense, the perspective provided by the GDPR with the same origin and perspective anchored in fundamental rights, it's a good fit for the legal culture and the perception of Latin America about how the right to privacy and the data protection, it's an enabler of the exercise of other fundamental rights. And the influence is natural also because at the international level, the GDPR have become the most advanced standard in terms of specifying the rights of the user, of the data subject, and having a comprehensive approach in how these provisions have to be dynamically implemented in terms of the evolution of the technology. That being said, it's also relevant to acknowledge the influence that the privacy principles coming from the OECD have had in the recent history of Latin America data protection regulation. And this is linked with the fact that it was already mentioned by my colleagues that there have been recently Latin American countries that joined OECD, and also many more that are interested in being part of OECD and then looking into the full set of policies that need to be implemented to be updated and able to meaningfully participate in the group. And in that sense, in an intermediate time since the first round of data protection regulation in the region that happened, the first one 20 years ago, that were heavily influenced by the European regulation at that time, the directive before the GDPR, but also the national development in different European countries. After that first period of regulatory trends in Latin America, we lived for a couple of years in which other standards as the privacy principles coming from the OECD have a lot of traction and much more direct impact in the influence of the legislation that were many times being discussed, but many times they didn't have enough political track for becoming in legislation, but they went through a very long process of discussion, either for implementing a data protection legal framework in the countries in which they didn't exist, or for the updating of the data protection regulation in the countries in which already exists some of this. And in that sense, the principles, the privacy principles coming from the OECD provide maybe a more straightforward path. It was simpler to look into the set of principles that were identified and provide also a set of guidelines that were perceived as the Latin American countries as something that it was more accessible for some of them that didn't have much experience in the subject matter, that they still have to work more in order to insert the culture of privacy protection in their businesses and in their government apparatus, in terms of really make this something that it could be cross-cutting and transversal of all kind of activities inside of the country. So in that sense, I think that the influence of the OECD privacy guideline had been enormous during the last 30 years, and until the GDPR arrived, probably was even more influential than anything else in the region. And another example of that is also that some of the countries of the region and are members of the Asia-Pacific Economic Cooperation, the APEC, that also create their own privacy framework, and a lot of that is also inspired and connected and have coincidence with the guiding principles coming from the OECD. So that being said, I think that now there is a need of looking into this framework also as an inspiration for moving forward, and looking into the revision that the privacy principle have had in the recent years, particularly to stress some of the points that my previous speaker have highlighted, but I want to highlight them in a slightly different approach. One of them is the accountability principle that Giovanna just was talking to us in the previous intervention. And in that sense, I think that it's really relevant to understand the accountability principle as a piece that is essential for the incorporation in all the legislation, but not only from the perspective of the corporate responsibility, which of course is necessary, but in the sense that this need to infuse the culture of all the institutions inside a country, and particularly the public institution that heavy deal with the use and collection and processing of data, personal data, in the interaction with the citizens. And I think that this accountability principle had been not enough and deep being addressed in many of our countries from a private perspective and from a public perspective, when we think about the connection of the accountability principle with all the issues regarding to security and the need of provide transparent information to the data subject when there are cases of breaches and all these norms that try to establish the obligation of notification in the case of data breaches, need to be accompanied with a real infrastructure that allows to really be efficient in this type of communication and have much more interconnection between public and private organization in order to make this notification system meaningful for providing an infrastructure that is resilient and able to respond to this type of situation. And in connection also with this accountability principle, and particularly the side of accountability principle that I was mentioning, that not only have to be required from the corporate responsibility, but also from the public bodies. I think that we need to stress much more the principles from the OECD that come from the national implementation that request the development of the national privacy strategies that can reflect and coordinate approach across governmental bodies, because this is not enough put in a priority level for many of the Latin American countries that have implemented some kind of data protection regulation. So accompany the need of having this privacy enforcement authorities, to what Miriam and Christos already have talked a lot, so I'm not going to repeat. There is a need that the issue of protecting privacy and really enforcing the rules of data protection is not only perceived as the task of a main privacy enforcement authority, but it's perceived as a responsibility, the same that the corporate responsibility of the companies according to the accountability principle is also perceived by the bodies of the public administration that have on hand policies that implement technologies and other data, personal data intensive uses. And this is something in which is really behind for the rest of the country. So I will leave it there, and I will be happy to take questions around anything. Thank you very much.
Thank you so much, Maria, especially for pointing out and highlighting the challenge of accountability principle, and how this is the core element for the whole toolbox for international data transfer. I would like to also to make some comments at the end of this panel. I would like to move to Carolina, and especially to hear more about the role of civil society in that policy framing. So, Carolina, I'd like to ask you what is the role and how you are seeing it playing in setting the agenda for data protection at the OECD, and please talk more about the work that is being conducted in the CISAC steering meeting and how it can or cannot help to translate the inputs from civil society into concrete policy making.
Thank you very much, Bruno. Thank you for the invitation. So I am Carolina Botero, CEO of the Marisma Foundation, located in Colombia. But we are also part of the CECISAC, that is the group of civil society that participates in the OECD discussions. I'm also part of the steering committee of CECISAC, and well, I will try to say why, from a civil society perspective in Latin America, we were interested to join the OECD. Despite the fact that, of course, this is a shift of fora, we are usually we're usually working with fora that address the topics from a human rights perspective, whereas OECD has a development and economical point of view. So it is by no matter the influence of OECD is very important. It's well known international, and public policy has a lot to thank from the work that OECD has done during the last decades. The way OECD address public policy is from an evidence base, which means that they gather a lot of information and have very good teams of technical and knowledge evaluators. This goes into one of the probably most important differentiate aspects of OECD before any other similar organism, which is that they gather data directly from the government, and they do it, as somebody already mentioned, in a global scale. So they are able to gather, analyze, and produce information from very important data sets of the government. And not only that, when they produce documents, they consciously produce also follow-up and measurement index that allow governments to continue the assessment of public policies. Moreover, as already some other of the speakers told, there are inside mechanisms such as the Going Digital that allow the governments to have follow-up structures to identify what's working, what's not, and adjust public policies. This is something interesting that is not always found in our countries. So the fact that you are promoting and moving forward these kind of solutions is something that interests civil society and should be more highlighted than it has been so far. There is a context of multi-stakeholder engagement. It's already been mentioned as well, but one needs to stress this. There are spaces for the different stakeholders to participate, and even if the logics or maybe better, the times of reaction for each paper is very short, the rules are clear and everybody is able to participate and provide a voice. There are, of course, some problems, as for instance, civil society has, if one can measure how the different stakeholders participate in OECD, I would say that civil society is probably one of the ones that participate the least, at least in their own structure of multi-stakeholder process. And that might be, of course, responsible the fact that there is little funding, and therefore it relies a lot on the self time of the organizations that are engaged. This policy making process analysis of OECD relies a lot on the membership. Therefore, one could say that it is more a club of rich countries, but it's been broadening the scope. Colombia is now part of it, but it also means that usually most of the data that is provided, the cases and so on, it's basically from rich countries. You can see when one participates in OECD that there's a lot of participation from Asian countries, for instance, Europe, of course, US. And now that they are open to other countries, this is happening, but there is, of course, asymmetry. You can see the explicit intention to include diversity, but there's still lack of diversity, and that has to be acknowledged as well. OECD, I'm sorry, the OECD documents are used by governments, members or not. They are used, and therefore they are influential. But this has also been the case in issues of privacy and data protection, as had been already explained. I was going to make some points on how in Latin America the tension between the human rights or the person-centered policies such as the GDPR is probably more influential right now than the vision of OECD, but still the way OECD has influenced the GDPR and the way it provides good practices, mentorship, and follow-up to members in Latin America will end up being something of a balance. But this has been much more detailed by Maria Paz, so I will not stop there, except to probably add to what she has said, that one has to remember that Latin American countries, or many of Latin American countries, had incorporated into our constitutions data protection, alias data, on all these concepts. Therefore, the framework of person-centered and human rights is much more clear there. And this is to say that also has been already said, but the review of guidelines was much more direct to practices, to how it impacted, how the implementation was, what are the cases, what are the recommendations, and found that most of the wording of the guidelines back from years ago was still accurate and working. So this is an important issue because it put us in the framework that OECD will be looking at in the next years on issues of privacy, which is the implementation, the practical use, and of course the cases. And also mentioned by Christos, The OECD has been working on research on specific topics such as data localization, but also artificial intelligence, digital security, children's safety, and all this work is going to feed back into what will be promoted by the OECD as good practices and best ways of dealing with data protection and privacy issues. So I would just say that by following the OECD discussion during the last years, it will be wise to identify those implementation and practice issues. And there is where the most of the challenge for civil society will arise. And I would just like to finish my intervention with probably 4 of the ones that we've identified. The first one is that since there are just few members of Latin America that are part of the OECD, the information that will feed the OECD and will be used in Latin America is partial, and it will need an decision to diversify it. Our context is still very different from the documents that usually the OECD has, so the need to localize recommendations and so on, it's much more needed in Latin America. OECD language is development and economy, and usually civil society comes from a more human rights oriented language. Therefore, there's a need to translate and find out how to do it better. The last one will be that CCSAC needs much more engagement. There's a lot of a big, broad constituency, but the organizations that actually participate in OECD are less. I will finish there so that we can have some time to do something else. Thank you, Bruno.
Thank you so much, Carolina, and to give a very detailed analysis about the force correlations also in the CSAC. I'd like to make a closing statement to just summarize our discussion before to take some few questions from the audience. And I would like to connect, if I may, the whole discussion that we had here with some findings that I'm discovering in my PhD research. When we lived in a world without a pandemic, I was able to spend a few times at the OECD's headquarters and to gather some materials. I dug into microfilms to better understand what was being discussed at the expert group responsible for the first draft of the guidelines, and I also had access to the summary of several seminars held by the working group on computer use back to 70s, which gathered the intellectuality of data protection at that time. These things are not online available, but I'm glad to share with who is interested. And this whole journey has shown a very detailed dispute between 2 regulatory models to enforce data protection. One is self-regulation, and other is a regulation, particularly through command and control techniques. For instance, in the seminar that I just mentioned in 1974, Alan Westing, Arthur Miller, the most known American privacy scholars in USA, Stefano Rodotà, Spiro Smith, who occupied the same position in Europe, pointed out this regulatory tension. And in this same sense, Michael Kerb, former justice in Australia and also president of the expert group responsible for the first draft of the guidelines, remembered that the group would not invent the wheel in terms of creating the content of data protection norms, since there were already existed the so-called information practicing principles. The main goal and the main role to be played by OECD was to find a way to harmonize different regulatory strategies to implement those norms. And I would say that this goal was not fully achieved. In this sense, in 2008, the OECD has started to use a new terminology, interoperability, instead of harmonization. Full convergence would not be possible, but we could perceive normative synergies that would lead to equivalent outcomes in terms of enforcement, even though they are differently transnationalists in how to achieve it. The best example to illustrate this is the toolbox for international data transfers. Nowadays, we see European norms such as GDPR and even South American laws, data protection laws such as GDPR, that are interoperable with North American regulatory rationality by adopting seals, byte corporate rules, BCRs, and other instruments for transborder data flow. However, in Shrines 2, we have a clue that those contractual instruments are also being challenged, or at least being discussed. And that attempt to balance less state intervention with more organization accountability does not always succeed perfectly. So in other words, it's not that simple to measure the achievement of similar outcomes through different ways, even though there is interoperability between different legal and institutional arrangements. So having said that, I'd like to leave this for reflection, and I would like to thank you, the distinguished panelists, for pointing out those challenges, the advantages, and also the perils of regulatory convergence, in particular, taking into account the context of South America. And now I would like to take some few questions from the audience. The first one is from Clarissa. Clarissa is directing this question to Giovanna. And the question is, if I understood well, in your view, accountability frameworks, therefore privacy regulations should be used as enablers of data flows or legal interoperability instruments. Following this reasoning, they would then replace international agreements on the subject. It is enough, in our view, to provide a sufficient protection of fundamental rights?
Thank you so much for the question. They're not viewed to replace. They work together with data protection laws. Accountability frameworks are ways that organizations from the public and private sector can use to actually comply with the laws. So they're complementary, and they also work as an extra layer of protection, because organizations don't use them just to comply. They use them to embed a data protection culture within the organization, to put data protection in the corporate DNA. And they see the benefits from that, because one of the results of becoming accountable is that you protect personal data and you comply with the frameworks, and therefore you can transfer personal data across the globe. So I would say data flows is one of the results and one of the benefits that companies and private and sector organizations have of becoming accountable and implementing frameworks. And then the frameworks are one of the ways that organizations use to effectivate their compliance and go beyond that compliance.
Thank you, Giovanna. We have a few minutes. I think I'd like to give the floor for the panelists to summarize or just say something in 1 minute each, and then I think we are done. So I think we can start with Christos. 1 minute.
Yes, thank you, Bruno. Well, I mean, there are some interesting points that have been here made in this panel, and I'm glad that they have been raised. Just one thing that I would like to put forward is like the OECD. I mean, as it has been mentioned already by Miriam, Giovanna. I mean, They're currently working on really cutting-edge issues, and the work of the OECD, perhaps we were very briefly explaining in like 8-10 minutes here, but it's much more complex than what it is. And the OECD is actually the one international organization that really engage different stakeholders. So when they are going to create a policy, whether it's a revision, whether it's going to be an interpretation of a guidelines, they really do a good work in organizing workshops, different consultations with, with the different communities, with the civil society community, with the technical community, the private community. And for instance, all that report, going back to the report of the OECD Going Digital in Brazil, I mean, it was a complex, project. I mean, it was something that was not achieved within 2 or 3 weeks. It was a whole project that was developed within the framework of 2 years. And as it was clearly already mentioned by Miriam, I mean, the OECD also, included different consultations with government ministries, also private actors and civil society to hear their views on the different issues concerning, well, in that case, the upcoming regulation, the LGBT, but also, also things concerning on the legal framework at the time in Brazil. So that's what I just wanted to say, that the OECD is very inclusive. It's the one international organization that is actually, working really specifically in furthering and implementing policies with regards to privacy and data protection, and that includes countries of Latin America as well.
Thank you, Christos. Carolina?
Sorry, it is true, and I would say that is one of the most interesting things of engaging with OECD is precisely the multi-stakeholder, their intention to diversify and to hear from different people. I'm sorry, I started here during the night, and now I'm under this light, so I'm sorry. But I would also add there that, and it might be also because there's no enough data from the governments in very small countries or in other places, but there is a need to diversify. And I've seen, especially during the last months, OECD has been doing a more intense effort to include other countries. That was very interesting during the COVID response. They included many data from very different countries. And if we manage to keep that trend, impact and I would say the better practices in regions such as Latin America will improve. I'm sorry. And just to finalize, I would also say that from a civil society perspective, the engagement with OECD requires a very big effort, but it's worth. We need to learn to translate our human rights concerns into other kinds of discourses, and that is important.
Thank you, Carolina. And yes, and also I'd like to share that data privacy is also part of CISAC steering committee alongside ADC and other organizations from South America. And I'd like to move to Maria Paz Canales.
Thank you, Bruno. Thank you to all the speakers. Have been really enlightening this conversation. I will highlight one concept, which is policy coherence, that it's connected a little bit with the answer that Giovanna was giving to the question that was raised by the public, in the sense that the implementation of the accountability principle, that is one of the additions to the original framework, that it was worked in a much more detail in the recent revision. I think that it's relevant to understand that this principle need to be implemented in the private sector and in the governmental bodies in a similar way. I know that that's in the spirit and in some of the wording of the way in which this is implemented, but usually I have the feeling that in the role of pushing and promoting the implementation of this principle, much more of this have been said regarding the role of the companies than from the side of the governments, and how these principles, as I mentioned in my previous intervention, need to be complementary with the existence of the data protection authorities that are technical, independent, and with all the other requirements that are specified in the guideline. So I think that also in this sense, to understand and really have privacy policies that permeate the culture of each one of the institutions in the private and public side, it's essential. As I mentioned in my previous intervention, this is not a task that need to be located exclusively in the role of the ones that are in charge of enforce data protection regulation, but it should be a part of the agenda and the political view of any governmental body that is the leader in setting any kind of policy strategy that is based in the use of personal data. So I will stop there, and I'm really happy for this conversation. Looking forward for more interaction with the other speakers. Thank you.
Thank you so much. 2 minutes left, Giovanna, and after Miriam, please.
Really quick, I want to see more Latin American voices in global fora discussing data protection and other issues like data localization, artificial intelligence, and representativeness as well of multiple stakeholders, as we see in this panel, civil society and regulators, but also I want to see Latin American governments and organizations also participating actively in these debates and becoming accountable, facilitating global data flows, facilitating economical development. Thank you.
Miriam?
Thank you, Bruno. I'd just like to highlight that from a government perspective,
You're on mute, Miriam.
Can you hear me now?
Yes.
Okay, great. So I'd just like to highlight that from a government perspective, OECD is a relevant organization because it's a space where we can reach broad consensus on important issues, and these consensuses then trickle down towards other international organizations where binding decisions can be negotiated and made. And OECD recommendations have in fact historically provided important guidance for countries wishing to implement reforms. This is true also for Brazil. So I'd just like to highlight the importance of this organization and the relevance of the recommendations that have been made specifically in the field of privacy and personal data protection. Thank you very much, Bruno. It was great participating in the panel.
Thank you so much. It was a really worth discussion. And I'd like to conclude by saying that I really miss Brussels and the whole vibrant data protection community. I hope that we can see each other personally next year.
Thank you very much, Bruno.
Thank you.
Thank you.
Bye.